Good evening. The Town of Los Gatos Planning Commission meeting of Wednesday, September 8th, 2021 is now called to order. This meeting is being conducted using teleconferencing and electronic means consistent with the State of California Executive Order N29-20 dated March 17, 2020 regarding the COVID-19 pandemic. The live stream of the meeting may be viewed on Comcast Channel 15 or online as noted on the agenda. In accordance with the order, the public may only view the meeting on television or online and not in the council chambers. Director Paulson, we are conducting tonight's meeting in a virtual setting using Zoom. All planning commissioners and staff are participating from remote locations, and all voting will be conducted by roll call vote. Director Paulson, would you please call the roll?
Thank you, Chair Janoff. Commissioner Thomas.
Present.
Commissioner Barnett.
Present.
Commissioner Suzuki.
Here.
Vice Chair Birch.
Here.
And Chair Janoff.
Here.
And Mr. Tavana is not going to be able to join us this evening.
And Commissioner Hanson.
Director Paulson, did you want to acknowledge that I was here?
Yes, I guess I probably should. Thank you for that. Commissioner.
I'm here.
All right, great, thank you. As the Planning Commission conducts this meeting on behalf of the Town Council and residents of Los Gatos, we encourage active participation, which is essential for democracy and critical to the work of the Planning Commission. Your participation can occur through written comments about agenda items submitted to staff prior to a meeting, which are always welcome and helpful. During our meeting, there are two opportunities for members of the public to participate. During the verbal communications period, an individual may speak on any topic not on the agenda. And during the hearing on a specific agenda item, any member of the public may speak about that item which is on the agenda. If you wish to address the commission tonight during verbal communications or during the consideration of the agenda item, you must join the Zoom webinar via the link and password provided on page 2 of the staff report. When I announce the item for which you wish to speak, please click the raise hand feature in Zoom. If you are participating by phone only, press *9 on your telephone keypad. When called to speak, please state your name and address for the record. Alternatively, you may choose to speak anonymously. It is requested that you limit your comments to 3 minutes. We've now come to the verbal communications portion of the meeting. At this time, members of the public are invited to address the commission on any issue not on the agenda. Director Paulson, do we have any members of the public wishing to speak at this time?
Let me take a look, Chair Janoff. Again, this is for items that are not on the agenda, and I do not see any hands raised.
All right. So the next item on the agenda is the consent calendar. We have one item tonight to be acted upon with a single motion. And this is the draft minutes of the August 25th, 2021 Planning Commission. Does any member of the commission or member of the public wish to pull the item from the consent calendar? I don't see any hands raised. So may I have a motion for approval of the consent calendar? Vice Chair Birch.
I will move to approve the consent.
Thank you. Do I have a second? Commissioner Suzuki.
I second the motion.
Thank you. Any comments or changes to the minutes before I call the question? I don't see any hands raised. So we'll call the vote. Commissioner Hanson.
I vote yes. I was not present at the meeting, but I was able to review the YouTube video as well as the minutes.
Thank you. Commissioner Tabana is not here. Sorry. Commissioner Barnett.
Yes.
Commissioner Thomas.
Abstain.
Commissioner Suzuki.
Yes.
Vice Chair Birch.
Yes.
And I vote yes as well. So the motion passes. So now we'll move on to the public hearing agenda, item number 2, which is to consider an appeal of a development review committee a decision approving a lot line adjustment between 3 adjacent lots on properties zoned R120 located at 17200 Los Robles Way, APNs 532-36-075, 076, and 077. Lot line adjustment application M20-012. Property owners Darren Goodsell, trustee, and Mark Von Kanel. Applicant Tony Jeans, and appellants Allison and David Steer, Terry and Bob Reinhardt, Nancy and Jim Neep, Gary and Michael Geisen, Jim Franco and Eileen DeFeo, and project planner is Ryan Safety. Are there any disclosures related to this item? Right, I don't see any hands raised. I understand, Mr. Safdie, you'll be giving the staff report tonight.
Thank you. Good evening, Planning Commissioners. Before you is an appeal of a Development Review Committee decision approving a lot line adjustment between 3 existing legal parcels at 17200 Los Robles Way, zoned R120. No construction is proposed at this time. The future driveways and building footprints shown on the project plans are conceptual and are not being reviewed with this lot line adjustment application. A future ARC and site application will be required for the construction and grading work. There's an existing residence on parcel 1, which would remain. Parcels 2 and 3 are vacant. Parcels 1 and 3 take access off Los Robles Way, and parcel 2 is landlocked. There are 4 existing nonconformities associated with the 3 parcels, including setbacks of the existing residence, minimum lot size of parcel 2, and minimum frontage requirements for both parcels 1 and 2. The proposed lot line adjustment would have parcels 2 and 3 take access off of Worcester Lane, while parcel 1 would continue to access off of Los Robles Way. All existing nonconformities would be resolved, except that parcel 1 frontage on Los Robles Way will continue to be nonconforming. The DRC approval was appealed for a variety of reasons, which are summarized in the staff report. The full 90-page appeal packet is included as Exhibit 11, and the applicant has responded to the appellant's concerns included as Exhibit 12. Staff recommends that the Planning Commission deny the appeal, uphold the decision of the Development Review Committee, and approve the lot line adjustment application. A desk item was prepared and distributed today, amending the Parks and Public Works conditions of approval to ensure that consent from all holders of deeds of trust on the parcels is provided prior to recordation of the map. This concludes staff's presentation. Planning staff, Parks and Public Works staff, and the town attorney are available for questions. Thank you.
All right, thank you for your report, Mr. Safdie. Do any commissioners have questions for Mr. Safdie or other members of staff at this time? Commissioner Hanson.
I have 2 questions, if I may, Chair. My first one is, one of the things we're asked to look at is the compliance with the provisions of the general plan. So I'm asking staff, what aspects of the general plan should we be considering relative to this specific application? And then I have a second question.
So I can jump in. So most projects, you have to consider the general plan. With this becoming more conforming for the most part, except for, as Mr. Safdie mentioned, the one non-conforming frontage that's going to continue. They'll continue to have a non-conforming frontage for one of the lots. Right now, this is simply putting parcel lines on the paper, so there's no development. That development would be in line with provisions in the general plan, such as looking for ensuring that we're minimizing, grading and tree removal and things like that. So this project really doesn't affect any of that. But ultimately, the future projects, as architecture and site applications and or associated grading permits come forward, then we'd be looking at specific items related to development.
Okay, so just to summarize what I thought I heard is that the real issue that's on the table today is the zoning code, not the general plan. And that when the architecture and site application comes in, then we'll be considering aspects of the general plan. Is that correct?
That's correct.
Okay, so my follow-up question is on the findings in Exhibit 2. And it's about this subdivision map application. And it talks about on C and D that the site is physically suitable for the type of development and that the site is physically suitable for the proposed density of developments. So my question to staff is, since there is no architecture and site application, how do we weigh that into this decision that is about the lot line adjustment without considering the broader implications of this, which is that there will be development, at least on lot 1, if not on the others?
Sure, thank you for the question. Those are related to the Subdivision Map Act findings. This is technically a subdivision application for the town, but they're not creating any new lots. So I wouldn't take that very much into consideration. We do, as Mr. Safdie mentioned, ask them to put conceptual access and conceptual building areas on there, but ultimately all of those details will be dealt with moving forward. Again, this is a little unique. It's not an actual subdivision. If this was one parcel and they were subdividing into 3 lots, then I think a lot of that stuff would come into play. Similarly with the general plan, but because it is simply lot line adjustment for 3 existing parcels that were legalized and certified through a certificate of compliance.
Okay, so what you're saying is that we shouldn't give a lot of weight to the subdivision application findings in relative to this hearing.
So from staff's perspective, none of those findings for denial can be made. So when we look at them as whether they're applicable or not, none of those from staff's perspective can be made.
Okay, thank you.
Any other questions for staff? I do have one. Staff, I'd like to ask you to confirm, perhaps this is for the town attorney, but I wanted to draw attention to the last sentence of the staff report, page 8. This is the town attorney's office comment. And I quote from that. It says, the town must confine its approval of a lot line adjustment on its conformance to the local general plan, any specific plan, any applicable coastal plan and zoning, and building ordinances resulting from the lot line adjustment. So this is a pretty narrow scope for Planning Commission. Could staff or the town attorney please speak a moment to the narrowness of our task tonight?
I think exactly what you said is exactly your task, is to look how the lot line adjustment will comply with our general plan and zoning. The reason for this statement and the law that's cited is that the appellants are trying to state that you can't do a lot line adjustment if it currently is non-conforming to make it conforming. And that simply isn't how state law and cases are. You don't look at what it currently exists. It's what is it going to be when the lot line is completed, and how does that comply with your general plan and ordinances. And so that's why that statement in that law was explained to you, is they were trying to say, because it currently these lots are non-conforming, you can't change them. And that's simply not what the law states.
Okay, so that clarifies that. Any other questions for staff? Okay, don't see any hands raised. So now we will open the public hearing. We'll start with the appellants, who will receive 5 minutes to address the commission. There are a number of parties speaking on behalf of the appellants. So we're looking for primary speakers to summarize your appeal.
Thank you, Chair. So the appellant, Ms. Steer, will be allowed to talk. And again, Ms. Steer, you and your group have up to 5 minutes.
Okay, thank you. Just a minute, I'm going to start my clock. All right, so good evening, and thank you very much for your time this evening. I'm speaking on behalf of the appellants. First of all, I'd just like to speak to that discussion you just had regarding the SMA. The town attorney cites the Subdivision Maps Act, section 66412. Oh, can you go to the next slide? Sorry, Ryan. Shown here. But I respectfully contest that this interpretation of the government code to be overly broad. The SMA is silent on when LLA procedures can be used, whereas the ordinance is explicit that it cannot be used under these circumstances and therefore takes precedence. The Subdivision Maps Act, in fact, allows jurisdictions to decide how they regulate LLA procedure and loosely provides the minimum requirements that need to be met. So I would just contest exactly what was just said prior to us being able to speak. I would encourage the Planning Commission to read this subdivision map section and draw their own conclusions. Again, if you read it really carefully, the SMA states that if the lot line adjustment is approved by the local agency, then the local agency shall limit its review to whether or not the parcels resulting from the lot line adjustment will conform to the local general plan, and that no conditions shall be imposed. Again, I encourage you all to read it carefully for your own conclusion before you make your decision. Taking a non-buildable site and making it buildable is not allowed in Gatos. And I've found examples of other counties that do the same. I've also affirmed this with a land use consultant. We contend that this ordinance is not in any way inconsistent with the SMA and is in fact enforceable. The Town Zoning Ordinance 2019-070 exists specifically to prevent developers and property owners from taking a non-buildable parcel and turning it into a buildable parcel using lot line adjustment procedure. The town ordinance includes the requirement for certificate of compliance, but also lays out 7 other requirements before lot line adjustment procedure can be used. Next slide, please, Ryan. In Napa County, for example, they also reference compliance with the section of the SMA, but they specifically state that a non-buildable parcel will not be made buildable by lot line adjustment procedure. And then they go into what they determine as a building site, which has to be free of geotechnical hazards and also has reasonable access, which this land does not. It's a landlocked parcel. So next slide, please, Ryan. And the same goes for Santa Cruz County, where it states that the lot must be buildable before a lot line adjustment can be approved. A lot that is not buildable for whatever reason, for example, lack of access or an unstable slope, it cannot be made buildable by means of a lot line adjustment. Essentially, Santa Cruz says that the LLA between parcels cannot result in more buildable parcels than before, which is what this developer is trying to do. We only have 2 buildable parcels on this lot, and you're turning it into 3 buildable parcels. Next slide, please. We have provided incontestable evidence to the signed Harding Ave quitclaim deeds that no legal access exists today for APN 532360077, and therefore this land fails to meet the criteria in the town zoning ordinance for a lawful parcel of land. This alone is sufficient grounds for the Planning Commission to grant this appeal and deny the LLA. Staff has made a recommendation to deny our appeal, but for the town to blatantly disregard their own town ordinance would set the stage for legal challenges and set a precedent for future illegal use of the LLA procedure to establish a conforming parcel. We are specifically focusing on bullet 5, which requires there to be legal and adequate access for vehicles and safety equipment, although I would also call into question bullet 4 for slope stability standards, given this lot has slopes in excess of 30%. I would ask why the town has not required the developer to provide evidence of slope stability on this hillside before utilising the LLA procedure, and why would this ordinance even exist? Next slide, please. The developer has contested that it would not in fact be required to build within the LRDA, but the Los Gatos Hillside Development Standard says otherwise. The hillside standard also applies to R1 zones with hillside sensitivity. There is no suitable place to design an emergency vehicle turnaround on this parcel with a consideration to the LRDA. And we have already proved there is no legal access. Next slide, please. So hypothetically, if a right-of-way existed, the driveway to access the property would be greater than 150 feet and would need a over 70-foot turnaround implemented, not exceeding 5% grade in any one direction. Where and how would this be implemented on the existing parcel? You must clearly show you meet all 8 criteria in the town ordinance before you can use the LLA procedure. Next slide, please, which I'm probably not going to get to because of the time limit. But thank you very much for your time tonight. And I hope that if your decision was already made before you came, that you'll take careful consideration of the interpretation of the SMA section that was referenced earlier.
All right, thank you for those for your presentation. And I have a question for the town attorney at this time. Based on the presentation by Ms. Steer, can you please comment on whether the points she's asking us to reconsider are valid or not? We do trust our town attorney also, and so for the Planning Commission to do a legal interpretation of material just presented, we'll call on you to guide us.
I've given my legal opinion and nothing changes. The lot merger language is inapplicable and unenforceable by the SMA, and also the lot line adjustment language that she quotes. If you read the next sentence, it says exactly your narrow scope is to look at the lots when they're completed and not as they currently exist.
And so just to clarify, is it fair to say that the establishing criteria that this is developable property is at this time theoretical, in the sense that we don't have plans for development, and should the development plans come forward and it's determined by engineering review or other experts that it is not a buildable site, that it is unstable, then it would practically not be possible to build. Is that correct? Question for staff.
I mean, it is possible at the end of the day to find out there's no buildable space We've had many projects where there might be slope stability, grading issues, and other things where the building pad is very limited. And I'm thinking even Bella Vista, how many changes we went through that to limit the development of that went through a lot line and certification. And so we could have that same situation when you're said and done. It could be a very limited building envelope at the end of the day, but that's what will occur during the architecture and site review.
All right, thank you for that clarification. And again, just to confirm that discussion about buildability is not really the purview of the Planning Commission's task this evening. Is that correct?
That's correct.
All right, thank you. Any other commissioners have questions for the speaker or for staff? Commissioner Suzuki.
Because this is very important, I'd like to ask the town attorney to repeat his opinion on the presentation. I'm just taking pretty close notes right now. Specifically on what's disputed.
So the appellant's argument is that our ordinance overrules the Subdivision Map Act and the case law that has determined how mergers occur, but I didn't hear much on mergers. So I think maybe they've dropped that argument and now we're concentrating on the lot line adjustment. And the SMA is very clear in what your scope is, and it's limited to the effect of after the lot line is completed. And so, Joel, we can name, I've been doing this 32 years, and that the argument has never been that if there are unbuildable lots, you cannot do a lot line adjustment. And I'm trying to look up Napa counties to see where they have, but I do know that's a county. There might be different rules with counties, but I have not found any city that has the same language that we have that requires you to apply the lot line beforehand. And all I can assume is the ordinance is very old, around the time the Subdivision Map Act was applied, and we do need to go back and change the merger language and the lot line adjacent language so it confirms to the Subdivision Map Act. The Subdivision Map Act language is very clear that you apply what the lots will be afterwards and not before.
And just to clarify, the Subdivisions Map Act takes precedent over our local ordinance.
Yes, state law and case law will always take precedence over local.
All right, thank you. Any other questions at this time? Commissioner Barnett.
And for Mr. Schultz, is it correct that the lot line adjustment, if approved, would obviate the need for a subdivision map?
Yes, it does. I mean, they don't need a subdivision map because they already have 3 legal lots there. So they're just doing a lot line adjustment.
Thank you.
Okay, now we will move on and give the applicant up to 5 minutes to address the commission.
Thank you, Chair. Looks like the applicant, Mr. Jeans, will now allow him to speak, and you have up to 5 minutes.
Yes, could you put my first slide up so that we can start when that is up? Thank you. All right. Well, as we've heard, these are already 3 legal lots recognized by the town of Los Gatos. A certificate of compliance has been recorded. Parcels 1 and 2 can be accessed from Los Robles Way, but also have access from Worcester Lane. It's just never been used. Parcel 2 was created with Harding access and never used. It's now accessed from Los Robles Way. Parcel 1 and Parcel 2 have common ownership, and the owner can decide how to access that and where to put emergency turnaround. And a portion of Parcel 2 is buildable. The LRDA, the one main configuration there is just showing that there are trees, so we try to avoid trees when showing the LRDA, but that it is it is buildable. So this is the current configuration. Would you move to the second slide, please? This is how we want it to be. You can see that it's a much more appropriate use of the space. Parcel 1 would continue to have the house on it, and it would no longer have non-conforming setbacks. Parcel 2 and Parcel 3 would be accessed from Worcester Lane, and the current dead end of Worcester Lane, which terminates at a fence, would be improved by a cul-de-sac. Again, not part of this application, but when Parcel 2 and 3 would be developed, this would be the configuration that would provide conforming access to Parcel 2 and Parcel 3. Please move to the next one. So if you look at what the land is all about, you can see the 3 parcels, 1, 2, and 3. You can see how close the property is to the lot line between 3 and 1, which is why we want to reconfigure the lot lines. Also, you can see a good amount of space that is available reasonably for building without dramatically impacting trees. There's an area on Parcel 1 where the house is. There's a further area on Parcel 1 towards Worcester Lane, and an area on Parcel 3, which is fully accessible from Worcester Lane and could be built on. So if you look at how the configurations move, please, on the next slide, you can see that Parcel 1 retains better use of the land for the existing house. Parcel 3 would have good access for a buildable area right in the center, and Parcel 2 would have a very nice 1 acre, almost 1 acre area, even though it's R120 and the adjacent areas are R18. It would have plenty of room to get separation from any existing homes on the adjacent lots, which has been one of the primary concerns that people have had. Using access as a means to shoot this down really just belies the fact that what they don't want is a couple of additional houses next to them. So if you have questions about this, the details are on the plans. And I have put rebuttals in for each of the points that have been brought up by the appellant. And I think that this is a reasonable reconfiguration of the 3 lots, which, as has been determined, are currently legal, and the Subdivision Map Act and the Town of Los Gatos rules really don't give you a lot of room to disallow this configuration. So I ask you to ratify the unanimous decision of the approval of the DRC, which found no reasons, and deny the appeal. Thank you very much.
All right, thank you, Mr. Jeans. Do members of the commission have any questions for the applicant? Commissioner Barnett.
Although it may not be technically before us, can you clarify whether you've had communications with the fire department concerning the turnaround feasibility?
Yes, we have. And the fire department said either with or without the cul-de-sac, it would be workable as long as we were to put turnarounds on the sites themselves, Parcel 2 and Parcel 3. Parcel 1, we have not had a discussion as to how we would improve that to give better access and turnaround at the end of Los Robles Way. But when it is only one site involved, we would expect to put either a cul-de-sac at the end of the Los Gatos Way extension, the Los Gatos Way extension, or to put a fire truck turnaround there in any event.
Okay, thank you for that.
I do have a question for the applicant. Mr. James, in one of your communications in our report, this won't be verbatim, but there was a comment regarding whether or not you would be allowed to build strictly within the LRDA or not strictly within the LRDA. And your comment was it's guidance and it's not something that you're expected to hold fast to. My question for you is this. Are you aware of the recent decisions by this planning commission and previous planning commissions and the trend of the planning commission to restrict build within the LRDA and not allow any build outside the LRDA?
Yes, I am. And I think that is definitely the right way to go. The building sites that have been shown on the map that accompanied this application show that it is entirely reasonable to configure the house, the turnaround, the driveway, all entirely within the appropriate LRDA area.
Yeah, thank you for that. Yeah, I just wanted to make sure that you understood where the Planning Commission has been deciding recently. This is not germane to tonight's conversation, but it would be germane should plans come back before the Planning Commission.
I think it absolutely should be, and I'm in favor of that.
Great. All right, thank you. Any other questions? I don't see any hands raised from the commissioners. Therefore, we will move on to the public comments. Members of the public may choose to state your name and or address or speak anonymously. However, please understand this meeting is being recorded for the public record. We ask that you limit your comments to 3 minutes. Director Paulson, do we have any members of the public who would like to speak on this item?
Thank you, Chair Janoff. I do not see any members of the public with their hand raised at this point. Just give it a second here. Seeing none, Chair.
All right, thank you. So we will close the loop back up. We now give the applicant and then the appellant each 3 minutes to provide concluding comments. And so first up would be the applicant, Mr. James.
Mr. Jeans, I've allowed you to speak. If other members would like to speak, that's perfectly fine as well from your team.
Sorry, is it my opportunity to speak? Thank you. In the absence of any comment from the public other than the original appellant, I have nothing further to add other than to say that I think that the direction that I was given and that I just had to comply with the town zoning and zoning rules and subdivision map act are applicable here. And one of the things that we have ensured is that we have removed as many of the non-conformities that exist now in the new configuration. And I think you will agree that the planned proposed configuration is substantially better than the one that is now. So I ask you to approve it. Thank you.
All right, thank you for that wrap up. And now at this time, we'll ask the appellant if the appellant has any further comments to add to close this item.
Thank you. Give me 1 second and I will get the appellant back the ability to speak. Ms. Steer.
Okay, thank you. So at the beginning, thank you. At the beginning of this meeting, Mr. Polson mentioned this is a subdivision. I'd like to question why we're using the lot line adjustment procedure for the changes that are being made today. I just really want to reiterate that the Subdivision Maps Act, in fact, allows jurisdictions to decide how they regulate the LLA procedure. We're not talking about buildability. We haven't seen what they're going to build, but there is bullet 5 that says you need legal access and a turnaround. And that is in the town ordinance. It says that you have to have it. Parcel 2, as we call it, does not have this today. And that's written in the ordinance. what we're asking for is for you to basically deny this LLA and grant our appeal. We'd also ask that you maintain the existing primary access for these parcels from Los Robles Way. Quoting from the hillside standard, this would avoid unnecessary scarring and destabilization of the hillside through grading and removal of trees, because if you've been to the property, you'll see what it looks like at the bottom of Worcester Lane, and would assure a preservation of the natural scenic character of the town. In addition, this would ensure that the two remaining buildable parcels, because there's only two buildable parcels on this property, share a driveway and minimize the impervious surface. Because we have had issues with flooding from this hillside, we've had issues with landslide, it's falling into people's properties. We would like to keep the property access from the top of Los Robles Way the way it was originally intended. Again, the Subdivision Maps Act is very loosely worded. It actually, when you read it, it's only defining what would happen after the jurisdiction agrees to the lot line application, and the lot line application does not meet the requirements in the town ordinance. So I respectfully disagree with the town attorney on this. I think I would ask to see if there's any legal things that he can cite of court cases where people have been able to overthrow lot line adjustment using the SMA section that was specified here. We know that Tony Jeans is talking about these parcels being legal, but they're only legal in terms of certificate of compliance. And we know that that is often issued on interior parcels that lack legal means of access and can't be built upon under existing zoning codes. So yeah, unless you want to take that ordinance off the website and tell us what other ordinances aren't actually defendable in court, then I think this is a valid ordinance.
Thank you for your comments. Do any commissioners have questions for Ms. Deere at this moment? I do have one. Ms. Deere, the town attorney has advised us that state law takes precedence over local ordinances in this instance. Do you still assert that we should be following the ordinance contrary to state law? And that's just a simple yes or no question, please.
Yes, because the state law is very loose in its requirements. It's actually giving jurisdiction to the local ordinance, giving the jurisdiction to the local agencies. There's nothing in there specific to how to regulate the LLA procedure.
All right, thank you for your answer. Any other questions from commissioners? I don't see hands raised, so at this time I will now close the public hearing on this item and ask if the commissioners have questions of staff, wish to comment on the application, or introduce a motion. Commissioner Hanson.
I have a question for staff and then a comment. Okay, so after listening to all this, here's what's troubling me. We have these findings in front of us in Exhibit 2, and the findings are primarily in two areas. It's CEQA and the subdivision application. And if I go back to what was said earlier by staff and the town attorney, we're basically not to consider any of the actual findings for denial in the subdivision map application because they're not relevant, but then we don't have anything else to consider in terms of making findings. And if you just consider, the worthwhileness of the lot line adjustment in terms of making the property more usable and more buildable, that's very clear, but that's not in our findings. And so I remain troubled by, I understand that state law trumps local law, but I can look at several of the findings in the subdivision application findings that we have in Exhibit 2 and say that they don't apply to this project, but we're not supposed to regard those. So I'm just wondering if staff can help me how to sort through what we have to make findings for versus what I see in front of me.
So again, this is a subdivision application. And so what you look at is whether it's these findings or we have other town code findings that you have to make on a regular basis. And sometimes some of them aren't applicable. We still include them. or we say it's not applicable. And so maybe that would have been clear. This one is a little bit different in that it's in the reverse. Typically, you make these findings to deny a subdivision application. But the reverse actually is what we're looking to do here, which is make affirmative findings. I think that was based on a case from not too long ago regarding an actual subdivision application, not in the town, but somewhere in the state. And then I'm not sure if the town attorney has any additional comments. From staff standpoint, we have 3 legal lots. We have done a certificate of compliance, creating legal lots. They're now looking to modify those lots, the configuration of them through a lot line adjustment. And that's the path that we would go forward with. And that's why DRC considered it and approved it. And we obviously, I'm trying to remember the last lot line adjustment that was appealed, but this is how this has been done for the last 21 years I've been here. So I'm not sure if the town attorney has any additional comments on that.
I mean, my comment just goes back to what the subdivision map act says about lot line adjustments. And even though the appellant wants to say that you have local authority under our local ordinances, and it's very clear language in there. The local agency shall limit, it's a limit its review and approval to a determination. So you're going to make a determination of whether or not the parcels resulting from the lot line adjustment. So you're limited to your review and approval and determination of whether the resulting lot line adjustment will conform to your general plan, any specific plan, there isn't in this case, we're not in a coastal plan, and zoning or building ordinances. So you're limited to your review of when the lots are completed, not what's there and whether they're buildable or not buildable. But when they're completed, these 3 lots, are there any general plan or zoning ordinance that's it's in conflict with? And that's for your review.
Okay, so I think I understand that. So then if the chair would allow me, I'd like to make a comment. So my comment is this, that I totally understand what is being said by staff and the town attorney, and I also understand what the appellant is saying. And so aside from the very narrow legal interpretation of this, I feel like the steps of this thing were all wrong. It's already been decided that there are 3 lots. So subdividing a single parcel into 3 is already a done deal. And so now we're asking to reconfigure those so that they appear more like buildable lots, which I understand. And then we're going to be forced into this situation later on where we have property that's in the very high wildfire interface zone, which is very clear in our upcoming draft general plan that we don't encourage additional density. And so we're going to be forced in this situation where when we get an architecture and site application, it's going to be very difficult. It might not be possible to get the access approved to the lots 2 and 3, but now the lots are bigger and people will assume that they're buildable, and then we're going to run into Bella Vista all over again. So that's my comment. I just consider the order of things a bit problematic, and that we're putting the cart before the horse by making all these things to appear that it's more buildable and sellable, and then we have to do the hard stuff later. So that's all I have to say.
Just to follow up on your first question having to do with what the findings might look like. I actually was surprised to see that there isn't a finding that says we can find conformance with the general plan. And it would make me feel more comfortable, given the guidance from the town attorney, that we at least include that as a finding should this motion go forward. And I think because the new general plan, the current general plan and the upcoming general plan, both are asking for residential build, right? You can argue that even though this is not the ideal spot, this may not be where Planning Commission would approve lots. In theory, you're consistent with the general plan because the general plan is asking for residential build. So I'm comfortable with that. If that makes sense to the rest of the commission. I saw, was it Mr. Suzuki? Did you have your hand up?
Yes, I did.
Commissioner Suzuki.
I have a question for staff, which is, can the Planning Commission account So from my understanding, we can only account for what the completed lots will look like. Which leads me to my question. Can we account for a reduction in nonconformities? For example, from like 4 nonconformities to the 1 nonconformity that exists? Or is the commission only allowed to account for the 1 existing nonconformity? In other words, can we account for this lot line adjustment fixes a bunch of nonconformities, or we just scrap the before and we only look at the after? We only account for the 1 nonconformity at the end of the day, not the reduction in the nonconformities. Thank you.
Yes, I'd offer, and then if the town attorney has any additional comments, you're free to take in whatever information you want to which you use to base your decision ultimately. From staff's perspective, as you've mentioned, which is outlined in the staff report, we're generally trying to reduce as many nonconformities as possible. This reduces 3 of 4. We are still left with 1 outstanding nonconformity, but there currently exists a nonconformity for that parcel for the frontage. And so staff, from our perspective, this is improving the situation. And I would just, back to Commissioner Hansen's comments earlier, if this was, I think I mentioned earlier, if this was 1 lot right now and they were coming in to subdivide it for 3 lots, a lot more of this stuff would come into play. It's really the distinction between an actual subdivision through a parcel map versus a lot line adjustments of 3 existing legal parcels. So hopefully that answers your question, Mr. Suzuki, and I'm not sure if Mr. Schultz had anything additional on that one.
I see Mr. Schultz shaking his head no. So Commissioner Thomas, did I see your hand up?
Yes, I was trying to just add on to what you were saying, Chair, actually about the, my interpretation maybe is that if we find that this does comply with the general plan, that is, because that is written into the Subdivision Map Act, there's an assumption that that is included in as one of the findings. But I also agree with you wanting to add that as a separate finding.
All right, any other comments, concerns? Commissioner Barnett, and then Vice Chair Birch.
Yeah, my concern is that we have a property owner in the town of Los Gatos who has certain legal rights. They've been confirmed by the town attorney. And I think it would be inappropriate to deny the property owner with his legal rights.
Thank you for that comment. Vice Chair Birch.
My question is a bit more to the what next. The appellants did a good deal of research, and obviously they care very passionately about it. The Planning Commission, as a rule, is rather limited to very factual findings that we have to work within, and we are not able to look down the road and make any decisions right now based on future conditions, although I do believe that Commissioner Hansen is correct. When these come in front of the Planning Commission, there's going to probably be some difficult conversations and compromises that are going to need to be made. Depending on how we go here, I would just like to understand from the staff, do the appellants then have the ability to appeal our decision and move on to council with this, or does this end with the Planning Commission?
Thank you for your question, Vice Chair. So every action that the Planning Commission takes from a decision standpoint is appealable either by the current appellant or by the property owner or applicant, depending on the situation. So yes, after the Planning Commission takes action, whatever that might be tonight, I will be reciting those appeal rights.
Chair, if I may, then could I make a comment? I do very much see both sides onto this, and I do appreciate on both sides the amount of research that has gone into this. It's been actually a pretty enlightening packet of both the history and the different ordinances and different ways to view this. However, based on what we are tied to as a planning commission for our what we base our decisions on, I feel that we cannot, grant the appeal, that we will need to stay with the DRC's decision, but I would be very interested in hearing what my other commissioners think before I attempt a motion.
Yeah, I'll just weigh in on that. I think it's very clear what the limitations of the Planning Commission are tonight. We could continue this matter to do more research, but I'm not a lawyer. I'm not prepared to interpret the case law. That's what I rely on our town attorney to do. So we've been advised in that capacity. And I think Commissioner Barnett raises a very important point. So given, and again, the only thing that we are doing is approving the change in lot lines. We're not approving any development. The development that was presented as potential was a required threshold or step to take in order to say that these lot lines revisions are reasonable. So what we get in front of us, we can't predict what will come, if anything, before the Planning Commission. So we really are constrained by this one pretty straightforward question. So unless there are further comments, I'd be looking for a motion. Vice Chair Birch.
I'll make a motion, and if I misspeak, I'm sure somebody can jump in and let me know. I make a motion to deny the appeal of a DRC decision approving a lot line adjustment between 3 adjacent lots on property zoned R-120 located at 17200 Los Robles Way. I can make the findings that the project is categorically exempt from CEQA, and I can make the findings as required by section 66474 of the Subdivision Map Act. And the findings found, I believe it's in Exhibit 2. And I do believe, however, I might have been Commissioner Janoff or Hanson, I'm not sure, there was something you wanted me to add with the findings about the general plan. Could you remind me?
Yeah, as I was concerned that we might want to make the consistency with our general plan more specific. However, Commissioner Thomas did point out that that's already included in item B of the next finding. So I'm comfortable with it being there.
Okay.
And yeah.
Okay, great. And that is my motion.
And do we want to add Exhibit 13? I think that was also part of the.
My apologies. I knew I would miss a note. Yes, I do.
Thank you. Do we have a second for this motion? Commissioner Barnett.
I second the motion.
Thank you for that. Any further comments or discussion of the motion on the table? Okay, I don't see any hands raised, so I'll call the question. Commissioner Suzuki.
Yes.
Commissioner Barnett.
Yes.
Commissioner Hanson.
Abstain.
Commissioner Thomas.
Yes.
Vice Chair Birch.
Yes.
And I vote yes as well. So the motion passes, I guess that's 5 with 1 abstention. And Director Paulson, could you please comment on the appeal rights for this item?
Yes, thank you, Chair Janoff. So the decision of the Planning Commission is appealable to the Town Council. The forms are available online. The appeal must be filed within 10 days, and there is a fee for filing that appeal.
All right, thank you. We now move on to item 3 on our agenda, which is to provide the public with an opportunity to give verbal comments on the draft environmental impact report for the draft 2040 general plan. No action is to be taken at this time. Project planner is Jennifer Armour, and Ms. Armour, we look forward to your staff report.
Good evening, Chair, Vice Chair, Commissioners. As mentioned, a draft environmental impact report has been prepared for the draft 2040 general plan. As required by the California Environmental Quality Act, this public hearing is being held during the 45-day public comment period for the draft EIR. The public comment period ends this next Monday, September 13th at 5 p.m. Comments can be sent in writing to the email address for the general plan update, which is gp draft2040@losgatosca.gov, or submitted via the general plan update website, which is losgatos2040.com. This public hearing is an opportunity for the public to provide verbal comments on the completeness and adequacy of the draft EIR. The public hearing is not intended for consideration of the draft 2040 general plan, nor the actual certification of the EIR itself. No action will be taken at this meeting. The Planning Commission hearing for consideration of the final EIR and the draft 2040 general plan has not been scheduled at this time, but is anticipated to be this coming October. The Town Council is the deciding body for both the EIR and the 2040 general plan, but will be making their decision based on recommendations from the GPAC and Planning Commission. This concludes staff's presentation, but I'd be happy to answer any questions.
Thank you, Ms. Armour. And do any commissioners have questions for staff at this moment? I don't see any hands raised. Commissioner Hanson.
I'm familiar with this procedure, having done this many times, but I wanted to ask the question for the benefit of everybody. If planning commissioners have questions, we will be seeing the general plan and the EIR. Is that the appropriate time for us to comment and make questions, or should we send it in at some other point?
Correct. We would welcome any questions. You're welcome to send them in to me if there's something I can help with. But at this point, the purpose of this evening's meeting really is to receive public comment. And there will be further discussion of the EIR once we have the response to comments, which are part of the final EIR that would be part of the package coming to you next month.
Thank you.
All right, thank you for that question. Any other questions for staff? I don't see any hands raised. Director Paulson, do we have anyone in the public who would wish to comment?
Thank you, Chair Janoff. First to speak will be Juliana.
Hello, good evening. My name is Juliana Pendleton, and I am a lifelong resident of Los Gatos and the Environmental Advocacy Assistant for the Santa Clara Valley Audubon Society. Thank you for providing time to give spoken public comment on the draft EIR for the draft general plan. I have appreciated being able to engage with the general plan update process over this past year. When I take my dogs on their early morning walks, I more often notice the types of housing lighting both in town and up in the hillsides. Last Friday, for instance, as I walked down the creek trail from downtown toward Lexington Reservoir, I noticed lights shining brightly from a house up in the hillsides. As I was driving on Shannon Road towards Short Road, I noticed a brightly lit up tree in the hillsides behind Short Road. As I pass houses throughout town, many lights, both decorative and for security purposes, are not shielded, not low to the ground, and are of a colder light. Lighting is a serious issue for species, habitats, and even humans. We are in the midst of an insect apocalypse, and recent findings are beginning to identify light pollution as a significant driver for declines in insect populations. Since Los Gatos is nestled into the Santa Cruz Mountains and contains a major riparian corridor for our watershed, the effects of lighting may be even more devastating. With the Biological Resources Report for the draft EIR, lighting is not listed as a potential biological impact to the surrounding area. With proposals for expanded lighting throughout town, I believe there should be a town-wide environmental review for lighting incorporated within the EIR. Moreover, the draft EIR discusses potential impacts to migration and wildlife corridors. However, there is no relevant wildlife corridor study to reference where these potential impacts might occur. A corridor study should be undertaken to determine where potential impacts may occur throughout the town. Finally, one of the draft general plan goals is to implement riparian setbacks where necessary. The draft EIR should discuss different types of setbacks, such as both lighting and development, from the riparian corridors. Other cities do require developments have a 100-foot setback from riparian corridors and a 200-foot recreational lighting setback to help protect sensitive habitats. Thank you for your time.
Thank you for your comments. Dr. Paulson, do we have anyone else from the public who would like to speak?
Thank you, Chair. Let me take a look. I do not see any additional hands for folks who would like to comment on the EIR for the general plan. Seeing none, Chair.
All right, then we'll close this. We'll close a public hearing on this item and move on to other business. Vice Chair Birch.
Can I ask a question in relation to what the last speaker said, although it is not like directly related? I'm not trying to engage. It's more of a procedural type of a question.
Is this a question for staff?
No. Okay. No, it was for staff, but if now is not the time, I will not do that.
Yeah. We're strictly taking comments. So
Understood.
Yeah.
Fully understood.
Yeah. There'll be time for those. Don't lose the question. We'll get to it soon. Okay. All right. So we actually will move on to other business, and we'll start with a report from the Director of Community Development, Dr. Paulson.
Thank you, Chair, Commissioners. So I just wanted to remind folks of a couple deadlines that are coming up. The first is this Friday at 4 p.m. We're recruiting for up to 4 folks to join our General Plan Committee to form the Housing Element Advisory Board as we move into the preparation of our housing element for the years 2023 to 2031. And secondly, I want to let folks know that there will be a joint study session on September 20th. On Monday, September 20th at 4 p.m. between Planning Commission and Council regarding the draft 2040 general plan.
All right, thank you for those comments. And I would just like to add that on that joint study session, I think this is going to be a very, very important meeting. So I'm hopeful that as many commissioners as possible will be able to join this. There really is substantial change in the new plan, as you all know. And being able to engage council so that we're all on the same page, at least in terms of what the scope of the general plan is important. And then, of course, the Planning Commission will see that next before it goes back to Town Council. So, encouraging you all to attend on the 20th at 4. All right. Finally, we have subcommittee reports. In addition to service on the Planning Commission, members of the Commission serve on several town committees. Are there any reports tonight? I see heads shaking. It's been a quiet summer. Okay. All right. Thank you all for participating in this meeting. It's now adjourned.
All right.